Hello, dear students. In my first class, yesterday I talked about the introduction part on American realism, wherein I was discussing as to how, according to the protagonists of this school, law is what the judges say. By this, what they're actually arguing is that this claim of positivists that certainty is achieved in law merely by having laws in black and white is a myth, because much of what is contained in black letter law still remains to be read, interpreted, and this reading and interpretation of that black letter law happens in the courtroom. And this reading and interpretation of the black letter law is not predictable. Is not predictable because of the certainty contained in black letter law is actually not there. This is what realists claim. And therefore, and this they say is not what we are espousing, this they say is the reality. And therefore, their insistence that ours is not a school of law, rather ours attempt is only to highlight a reality which is obscured in the popular theoretical narrative of what the law is, which is mainly influenced by the analytical positivist understanding of law. Now, in my last class yesterday, I talked about as to how when we say that a judge was actually biased towards a particular dispensation, and I even referred to the example of former Chief Justice Ranjan Gogoi, that people are actually now attributing, now that he has accepted the offer of nomination to Rajya Sabha, people are talking about the possible judicial favors which he may have given. While talking about it, okay, so the argument being made is that when a judge is partial to a particular government, he is not doing the right thing, which is obviously correct. But does that therefore mean that in law there was one right answer in every case that the judge adjudicated, and the judge was supposed to follow that path of finding that one right answer? Meaning thereby that what is being argued, that in every case there is an amoral, apolitical answer. Now, this, if that is what is being argued, this is again something which goes against American realist argument. Because when you say that a judge has actually favored the government in his judgment, you are actually endorsing what American realists are saying, that law in the form of black and white law, be it legislative provisions, be it legal principles, does not bind the discretion of the judge, and therefore law is what the judge eventually says by way of his reading of those statutory provisions and legal principles. But if while criticizing a judge, it is being argued that he favored a particular person or a state, the contrary argument cannot be that the only course open to that judge was to give the right answer in every case, whereby it is being argued that in every case which comes up before the court, there is always a right answer which is amoral, apolitical, completely divorced from any claims of morality. What is in fact being argued when a judge is being accused of having favored the government in his judgment is that probably he did not go in accordance with the intended or proposed objectives philosophy of the laws and principles that he or she was actually interpreting. It is wrong, therefore, to argue that he or she should have stuck to that one right answer which was there to be found. The reality is that there is no such right answer which is to be found. The right answer is always to be constructed, and this task of constructing remains a moral, remains at times political exercise as well. And this is a very important message coming from the American realists. So while criticizing a judge that he probably favored somebody, we must not therefore assume that the course open to him as a judge was only and only to give that one right answer. We need to understand that most of the times probably adjudication involves choices, and therefore and those choices are not dictated by the letters of law, and those choices therefore are to be dictated by sound conscience of an objective human being, which we believe judges to be. And therefore, if you pay attention to this particular point, I guess some of the students' queries from my last class could very well be clarified. That when we are saying that that answers in a given case are lying in the realm of law, that realm of law permits possibility of contrary choices. And what is being argued by the realist is that out of the contrary and multiple choices which are there lying in the realm of ought for the judge to pick, there is nothing in the black letter law which actually controls the discretion of the judge in making that choice. And that is the important takeaway. What therefore a judge should do? Now, if the black letter law he or she is supposed to interpret is not actually giving him or her that one right answer, what he or she is supposed to do? Now here comes the role of the underlying objective of the law that he or she is trying to interpret. And therefore that interpretation should be preferred which is in accordance with the objective of the law. Now, if the objective of the law is very straight and simple, and that objective very well fits into one of the possible narratives, which one possible interpretation in that case is actually showing, then the job of a judge becomes rather easy. And even though the answers are coming from the realm of ought, because the judge is actually relying on the objective, one can still say that this kind of judgment wherein objective is clearly to be found and the objective very well fits into the case at hand, probably the judge, despite answering the questions from the realm of ought, is not subjective in his decision making. But the point which American realists are actually highlighting is that this argument of interpretation being in the light of the objective of the underlying law is not always very clear, and that this space of arguing in the realm of the possible objectives and of possible philosophy which the law is actually trying to advocate remains contested. And since that domain remains contested, therefore it eventually boils down to which objective in the eyes of the judge is the underlying objective of the law. And therefore, keeping in mind that underlying objective which the judge finds to be the objective of the law, he or she would decide accordingly. And therefore, this is something on which the black letter law has got no control so as to guide the discretion of the judge. And this is a point which we need to acknowledge and appreciate as a very important contribution coming from the American realists. In this context, if we go back to our discussion from the classroom when we were discussing Ronald Dworkin's argument of one right thesis, and that every adjudication, howsoever complex, howsoever hard the case may be, always has a right answer. And therefore, he argues that in law there is no discretion, because in law adjudication is an exercise wherein the judge is supposed to find an amoral and an impersonal answer of every case that comes up before him or her. Now, this very well captures the popular understanding of adjudicatory role, and American realists are mainly trying to highlight that this popular understanding of the adjudicatory role of adjudication being amoral and impersonal is flawed, because it ignores the reality. The reality is that it is moral and personal, and it is therefore wrong to go by the theoretical understanding of what adjudication is. Now, we also need to understand why is it that the popular understanding of adjudication is always that it is an amoral and impersonal exercise. Here comes the role of the doctrine of separation of powers, because the moment you accept that adjudication is a moral and personal exercise too, you will have to then acknowledge and accept the fact that adjudication also involves lawmaking, because lawmaking is deliberate, moral, personal exercise. And if adjudication is also a moral and personal exercise and not an amoral and impersonal exercise, then you will have to accept that within the limited domain confined by the black letter law, within that domain at least, when it comes to interpretation of the same, judges also in that limited sphere do make law. And the moment you utter this word that judges make law, again the popular understanding of separation of power, wherein we are being told that judges don't make law, judges only interpret law, you find this argument of law being made by the judges inconsistent with the popular understanding of doctrine of separation of powers. Because under doctrine of separation of power, interpretation is a task wherein a judge is only supposed to find the already existing law, and therefore the judge declares the existing law, and that declaration of the existing law forms part of the binding judicial precedents that we know in the common law jurisdiction to be also an important source of law. But regardless of this, that binding judicial precedents are also an important source of law in a country like India, we do not treat that as an exercise of lawmaking by the judges. American realists are arguing that that is flawed. It is an exercise of lawmaking by judges, and that it is wrong to simply brush it aside as something which is ancillary, and ancillary to such an extent that we reduce it to an exercise of declaring the existing law. And here, American realist and the Ronald Dworkin's argument obviously are completely at loggerheads with each other. When Dworkin says in law judges have no discretion, howsoever broad may be the language used in the codified law or legal principles applicable, what Dworkin is denying is the fact that reading of that law is only possible by somebody for whom that black letter law is not providing conclusive guidelines. And if that is the case, it is probably not correct to say that in law there is no discretion. Now, Dworkin can still argue that in law there is no discretion, because he would again come up with his argument of talking in the sense of that ideal imaginary judge Hercules, and for Hercules, Dworkin says that he possesses no discretion, and he argues that when law makes any question adjudicatory question, he assumes that the judge would act like a Hercules. But this again is according to American realists nothing but a reiteration of the popular understanding of adjudicatory role, which is more theoretical than real. And this is to a great extent correct as well. So that's it for today. If you have any questions in relation to what we have discussed so far in American realism, you are more than welcome to write to me at the following email ID, which is manvendradnlu@gmail.com. Thank you very much.